Here's an update from the law offices of Robin Bresky.
The law offices of Robin Bresky is proud of an appeal in which it prevailed along with appellate co-counsel and trial counsel, Amy Beller. Their client obtained a per curiam affirmance of a trial court order in a dispute over the interpretation of language in a property settlement agreement. The decedent entered into the agreement as part of the dissolution of his marriage. In the agreement, the decedent agreed to leave 50% of his estate by will to the appellants. The agreement also said, except as provided in this agreement, each party may dispose of his or her property in any way. The decedent's will left 50% of his probate estate to the appellants by will in compliance with the agreement. However, a significant amount of assets passed outside of probate to Bresky's clients. The appellant sued, arguing that the agreement's language required the decedent to leave 1/2 of all his property to them. The trial court found that the agreement was unambiguous and it applied only to assets that passed by the decedent's will. The appellants challenged the trial court's order, again arguing that they should have received 1/2 of all of the property. The law offices of Robin Bresky with co-counsel Amy Beller argued that the appellant's interpretation was contrary to the plain language in the agreement. Their interpretation would have required the insertion of additional language that was not in the agreement. The agreement did not impose any contractual obligation on the decedent to arrange for 1/2 of his non-probate assets to pass into his probate estate. The agreement's use of the term by will limited the scope of the decedent's obligation to the assets that passed under the decedent's will. Thus, the words by will in this context required a finding that the agreement applied only to the probate estate. Furthermore, the appellant's position conflicted with Florida case law holding that absent specific language to the contrary in a property settlement agreement, the beneficiary designation in other non-probate documents such as an IRA controls instead of the property agreement. The 4th DCA issued a per curiam affirmance of the trial court's decision. This decision by the appellate court preserved the positive result originally obtained by the client in the probate court. The law offices of Robin Bresky, depth of research, strength of knowledge.
For more information, visit BreskyAppellate.com.